Hello, Accounting Weekly readers and listeners. My name is Nicolaas van Wyk. I am the editor for Accounting Weekly and also the CEO of the Chartered Institute of Business Accountants. Accounting Weekly is a publication of CIBA, and we started this because we felt that our own members and accountants in general need a bit of a more hands-on approach. We don't generally cover the news developments, so we're not like a financial publication. It is how do we apply changes in law in our accounting practices. So it's a specific accountant in practice approach that we have in Accounting Weekly. The website is accountingweekly.com, and you can also subscribe to the newsletter. So the focus of Accounting Weekly is to interview uh, influential stakeholders, government officials, policymakers, and also experts on recent trending news, whether it's a change in legislation, a change in standards, and whether it relates to accounting and tax, or in corporate law, or other relevant laws affecting an accountant in practice. We want to speak with the people in the know, and then also connect you with them, because it has to the system can only work if we all know each other, build a network, and can do referrals. So the person we're interviewing today is Edward James. I met him on LinkedIn. I was doing a research for Accounting Weekly and what we need to cover for the next edition, and just became aware of a recent steps taken by SARS to hold a bank accountable uh, for the taxes of their clients. So in that particular case, the what happened was the SARS is alleging that the bank did not follow proper procedures in evaluating the risk of the client, and that they're actually busy with money laundering. So and due to the alleged negligence of the bank, that client could move a lot of funds out of the country. And now SARS is saying there's lost taxes, and because of the bank's negligence, they want to claim it from the bank. And then just a few weeks later, I saw an article from James that he covered in his LinkedIn profile, and I can really recommend you to follow James, Edward James. And of course, there's lots to learn from the posts that he makes. It keeps you aware. And a little bit about Edward. He is a qualified attorney, but he's got a specific interest in corporate crime, and he's currently working with Pinsent Masons, and previously had stints with ENS Africa, and he also has an MBA, which I really think all attorneys should do if they are in the commercial field. Edward is a graduate from University of Cape Town, and I'm reading all of this from his LinkedIn profile. And then the two articles that's of interest. The first one was this new law that became effective in South Africa, and I don't think most businesses know about this change, where a failure to prevent bribery could land the company that doesn't have enough policies and procedures in place liable for criminal offences. And I wanted to speak with James about this. And then also a second article related was a new measure by the NPA um, called Corporate Corruption Settlement Policy, where, as I understand it, as a layperson, you previously only faced criminal offences and maybe jail time. You can now actually make a payment to avoid that. Something similar, I think we all watch television and these lawyer shows, and it's something that you see often on television where a settlement is made, which I think is a good thing. And both of these, I think, is at the backdrop of SARS being um, uh, facing big challenges in collecting the necessary taxes to make budget and to pay for whatever we need to pay for development and infrastructure and such. Um, and as surely as accountants, we've seen this, accountants in practice, SARS being much more strict when it comes to review of and verification of documents and auditing. And if a document isn't in place, if you want to submit a claim, then they're going to reject that. So it's much more stringent enforcement by SARS. And then you also see these two developments. Then it's clear that the state machinery is now focused on all the other avenues besides taxes where the state can can increase its revenue. And then simultaneously fight corruption and crime. So Edward is an investigations lawyer who focuses on corporate investigations and compliance. He's a partner at the global white-collar crime and investigations team of Pinsent Masons. Let me then allow Edward to give an introduction about himself, his career, what he's currently doing, and then specifically on those two new developments in our corporate environment and the space, and what the steps are that companies should do now to respond to these challenging times. Edward, over to you.
Hi, Nicolaas, and thanks for the introduction. It's a real pleasure to join you and the listeners and viewers today. A little bit about myself. I'm glad that you picked up on the fact that I have an MBA. I think all lawyers, in fact, all people who have to manage other people and businesses should do it. But I guess what is my day job? I have one of the best jobs in the world, I think. And that is that I get to investigate issues for companies, not just here in South Africa, but more broadly across the continent and up into the Middle East. And I get to help clients navigate the outcomes of those investigations. I think a problem we sometimes make as investigators is we just find the problems. We don't help clients deal with them. And that's something that I certainly focus on for a living.
That is very interesting, it is a very interesting approach and angle, I suppose, on the attorney sector. I know there is a lot of accountants moving into the forensic field, and I think it's a really growing area. South Africa is subject to a lot of attacks from overseas and from syndicates, so it's proper that we have the right procedures in place. So. Edward, please expand on those articles. Your first one related to, I'm just going to write from your post. Earlier this week, this was now 3 weeks ago, a new law came into effect in South Africa that introduces a failure to prevent bribery offence, similar to Section 7 of the UK Bribery Act. In this article that Edward wrote, he unpacks the new law and provides some thoughts for companies with mature compliance programs and international footprints. Not much will change, however, for those that haven't adopted adequate procedures yet, now is a good time to do so. Edward, just give us some background on this legislation and why it is now being enacted and what the impact will be on companies.
Yeah, so Nicolaas, I do think, and coming back to your point of accountants also moving into investigations and compliance, I certainly think with all these failure to prevent offences, not just here in South Africa, but globally, there's certainly going to be an abundance of work for lawyers and accountants and other compliance professionals. But a little bit of context to the journey of how we got here and what this really means. So this idea of a failure to prevent really came up for the first time in the UK legal system when it passed its Bribery Act in 2010. So that's about 14 years ago. And it was a very novel concept. And essentially what the UK law said was that if a company has somebody that's associated with it, and that person goes out and they bribe, the company will automatically be liable unless it can show that it took adequate steps or adopted adequate procedures to stop people that are associated from the company from bribing. Now, what is somebody who's associated with a company? Well, it's anybody who performs services for or on behalf of the company. So it's quite a broad definition. It can be employees, it can be agents, it can be a broader spectrum of persons. Now, that was the very first failure to prevent offence, and since then, failure to prevent has become all the rage, so to speak, because it's a way that governments and regulators can hold companies liable more easily. So it really does streamline the criminal justice process, and it creates a lot of incentive for companies to do the right thing and to implement compliance programs. Now, it's interesting, and I think that the case you were referring to, the tax case, was the SASFIN case that hit the headline about 2 months ago. And it's interesting that you draw those analogies, because if we carry on down this road and timeline, the next big failure to prevent offence in the UK was a failure to prevent the facilitation of tax evasion. So failing to prevent the facilitation of tax evasion. Now that was the next failure to prevent offence that they introduced. And more recently, and this is quite hot off the press, the UK government has introduced a third failure to prevent, which is a failure to prevent fraud offence that is in its latest piece of relevant legislation. So the UK has gone down a journey where they've expanded this idea of holding companies liable for what people do if companies don't implement proper compliance programs. Now, this idea in terms of corruption as one key issue in South Africa was picked up by Judge Zondo in the Zondo Commission, and he recommended to the South African government that we should follow the example set by the UK. And we should also implement a failure to prevent corruption offence. Now, that's exactly what has now happened. It took some time, and understandably so. Introducing any new law does take time. But we now finally have in South Africa our very own failure to prevent corruption offence. And the idea is very similar to the UK offence that came into force nearly 13 years ago. So it's a very similar concept, and it's basically if someone associated with the company goes out and bribes, the company's liable unless it can show it adopted adequate procedures. So you can imagine it's a pretty big legal development. It makes it easier for the state to hold companies liable for corruption, and hopefully it'll act as a deterrent for companies moving forward.
Sure, that is quite a eye-opener and an awakening, I'm sure, that everybody has to go through. There's a few questions I wanted to ask, and that the first one you mentioned, so it starts off with bribery. It now includes fraud, or it might in future, and then very interestingly, it moves into tax compliance and tax abuse. And I must say that I'm sure there's a strong appetite within government to expand the current statutes to include fraud and tax evasion especially. But now, and we all support the clampdown after Zondo. We've seen unbelievable evidence of corruption and very blatant corruption. I remember reading one of the Zondo packs, bits of it. I couldn't get through everything. On the Watson company, where they actually had the whole finance team packing the bribery envelopes. So there was this big pile of cash in the boardroom, and this is how Greasy explained it. And then the accountant and the CFO and the bookkeeper were sitting around the table, and they were packing the cash into the envelopes and the bags, marking it, and then he would come and collect it, Watson, and then take it off to whoever he's going to pay this bribe to. So that is flagrant and obvious, and even I'm thinking about VBS. There was about 450 people indicted for that case, the VBS Bank. So that's like not just one or two people involved. That's like half of the employees. I don't know how many were there, but it sounds like it's everybody. And then surely you want to stop it. And we're suffering for a very long time now. We've all been suffering under this corruption that's been hitting us. But what is concerning, though, would be implementing for all companies. I have to file my own taxes, and I just can see I'm spending more and more hours. It's now into days and weeks. I have a little rent apartment that I let out, and the SARS asks everything. I must submit them everything that I have on just a small claim, and that the cost of compliance is very huge for me now as an individual. And then I was thinking, if you calculate all of this times all the 2 million small entities, then the cost of compliance will be huge. Is there anything in the legislation that has a tapered approach or a different approach, or is it just everybody must apply and implement proper procedures?
Yeah, so I think you really do flag a good point, and really what the law is saying is that companies need to adopt adequate procedures. Now, we don't currently have a guidance, so we don't have any clear direction from the state or the courts about what adequate procedures will mean. In the UK, they have issued some guidance. The guidance has been around for a long time, and the UK has quite a well-developed system where it explains what steps you need to take as a company to be considered that you have adopted adequate procedures. But what will be interesting with our courts, and this is my prediction, so please take it as a prediction. It's not necessarily going to be the case legally, but what I predict is that when our courts have to interpret this new law, they will, of course, consider context. So if we look at a big JSE listed company, what is adequate for them will look very different for what is adequate for a small business or entrepreneur that really does have more limited operations. So I think that the reasonable approach, in my view, for the courts to adopt is that they will consider context, and that what is reasonable for small business will be different to what is reasonable for big business. That's at least my hope. That's my hope on the direction of travel, because it's only fair to expect more to be done if you are bigger, more complex, and face bigger risks.
I think there's a common sense approach, but then there's obviously officials that have to administer, and then there's certain revenue target that must be made, and over time, I'm sure the system will work itself out to have a reasonable and a fair approach. But from what I've seen in some accounting firms, and even when we do Accounting Weekly, we see horrific stories about accountants supporting, this VAT fraud and things, and it's not like an active participation. I'm sure some of them make these plans for evasion and things, but just not by viewing yourself as a post office. I think that happens very often. You just accept what the client is giving you, whether the numbers make sense or not. Some would file a VAT. I'm not saying it's widespread. I'm just using extreme examples, I hope, where a company would have no assets but submit a VAT input claim, and that obviously isn't the proper way of doing it, and clear tax avoidance. And as an institute, we've been pushing very hard for accountants to follow proper engagement procedures, and just applying your mind with the numbers that's in front of you. If we all follow those procedures, we can make a big dent in tax evasion and get more taxes collected where it should be collected, instead of SARS trying to get more revenue through penalties from compliant entities. But just your thought on the tax issue. Do you foresee, if it isn't already like that accountants could be held accountable if a tax approach is followed, where SARS can hold them accountable for not following proper engagement procedures, and then filing a VAT return, for example, that is inaccurate and causes losses to SARS? If you dare to speculate.
Well, I think it's an interesting point, and in addition to commenting on the tax point, I'd like to loop back to, why would a country want to go down this road in terms of revenue, right? So just touching on the tax point, I think that the SASFIN case, and I'm not involved in that case at all, but I think that'll be an interesting test case for us to see what happens. The target of SARS claim is obviously a bank. It's not an audit firm or a law firm in this instance, but it will be an interesting test case to help interpret the current law. Now, we don't have a failure to prevent the facilitation of tax evasion law per se in South Africa. But depending on the outcome of the case, it'll be interesting to see if the state chooses to go down that same route as the UK. Because, of course, the idea with any failure to prevent is that it just makes it easier to hold the company liable. So if there's a medium or large size audit firm and they do work for a client and they somehow facilitate something like tax evasion, if we had such a law implemented, it would make it a lot easier for the state to hold that firm liable, right? So I do think that depending on where this case lands, we may see some appetite for the government to implement a new offence. And I mean, the clear reason for that would be it becomes easier to collect money where money should be collected from companies that don't do the right thing. Now, just to the point of revenue collection for governments, right? And this, to some extent, does link to the second article that you referenced, Nicolaas, at the start, which is that coupled with, and these are separate legal developments but have happened in very close succession, but coupled with the introduction of this new offence of the failure to prevent corruption, the National Prosecuting Authority has also, in the last couple of days, published its policy on what they call alternative dispute resolution, or ADR. Now, what that means is that the NPA that makes prosecuting decisions against companies has said that quite publicly and in a clearly written out policy that it may decide to not prosecute a company in certain circumstances. And this isn't new, this isn't novel to just us as South Africa. It's something that many other countries have adopted in their legal systems. And the idea is really quite simple. If a company can do enough to make the state happy that it's effectively paid its dues, then the state can decide not to go after the company and not criminally prosecute it. And that speeds things up for everyone. It means immediately the state can get cash in its pocket from companies, and it doesn't have to prove guilt. It doesn't have to go through years, if not decades, of legal proceedings against companies, and it helps everyone. So to come back to your revenue point, it's quite clear that the South African government recognizes that some companies want to do the right thing, some companies want to pay if they have done something wrong, and there's a quick way to get a resolution that works for everyone. And what's also important, and you may not be aware of this, Nicolaas, but when we have, I guess, these big corruption scandals or big fraud scandals and the like that involve companies that, or multi-jurisdictional claims potentially. So, for example, the US Department of Justice. What might happen is if a company wants to resolve that and wants to resolve it in multiple places, it will negotiate a figure of how much it's willing to pay, and that amount will be divided between the different countries. So if you settle with the DOJ, that's Department of Justice in the United States, if you settle with them, they'll give you a discount for the amount that you agree to pay in your home country or where the offense happened, right? So it's a no-brainer, really. I mean, South Africa could have lost out on a lot of revenue if it didn't go down this road, because then instead of us as a country receiving some of these proceeds from big fines, it's just going to go to America or go to England or go elsewhere. And ultimately, we as a country are the victims of the corruptional crime. So a lot of these developments, they just make sense.
No, I agree with you, especially after the Zondo years and all those revelations. Yeah, some entities did start paying penalties, and it's actually good to see that there is this action. We also don't want to overburden the courts with these huge cases that required skills. Just the Zondo Commission alone, I think their account was more than R1 billion just to host the thing, and they didn't even collect any money. So it is hugely expensive, and if there's a better way to do it, then I think we all should support this. What do you think should be the next step for businesses in anticipation of preventing bribery within their entities, enhancement of policies, enhancement of procedures, and then maybe also as accountants, how do they inform their clients about this matter? And then maybe we can just end with how, if accountants have clients that's in need of criminal investigations or other forms of investigations that you do, just how can they contact you? Thanks, Edward.
Yeah. So, Nicolaas, so I think what to do is a key question. So this shifts us back to the failure to prevent offence, and I do come back to what I outlined earlier, which is you really got to look to what's reasonable for your business. So for bigger businesses, listed companies, larger companies, they really should be looking to have fairly robust compliance programs in place with specific measures that are aimed at combating corruption. Now, I do think the UK guidance and the 6 principles they lay out is a good starting point, and companies that meet the threshold that have to comply with effectively certain CIPC guidances already have to follow certain rules, or should I say that their Social and Ethics Committee is required to ensure that they follow certain rules. And so for people that are interested, it's CIPC Guideline 1 of 2018. Right? And whether you follow CIPC guidance as a Social and Ethics Committee or you follow the UK guidance, the measures are the same. So 6 simple things to do. Number 1, set the tone from the top. So senior leadership really should be visibly taking a stance against corruption. Number 2, do risk assessments. Now, these can't be just general risk registers. There should be a specific process that's documented to understand where you're susceptible to corruption. Number 3, adopt adequate procedures. So these are things like anti-bribery policies, codes of conduct, and the like. Those should be in place. Number 4, conduct due diligence on third parties on a risk-based approach. So really, if you're going to go and do a big deal, you're going to go and buy another business, you can't just be doing commercial due diligence. You should also be looking at corruption and reputational risk issues. Number 5, do training. And number 6, ensure that you do ongoing monitoring. So your risk is not static, your compliance program shouldn't be, and you should be coming back and improving. Those are 6 pretty simple principles that big business should be following. Now, for medium-sized businesses, obviously you're going to tailor that to your size. Smaller businesses, the same thing, right? But you should be trying to do what you can, bearing in mind your context and taking reasonable steps, right? Now, what should accountants do? And I really do believe that accountants play an incredibly important role in combating all financial crime. So that is bribery, fraud, tax evasion issues, and others. So really the role of the accountant, if you're working internally for a company, if you're part of internal audit or in the finance team, right, or you're working externally, the best thing that you can do is to really be on the lookout for things that don't make sense and ask the right questions. Now, as an investigator, Nicolaas, you can imagine I often end up looking at financial records and wondering, did nobody look at this and think this was odd? And did nobody ask, right? Because bribe payments are typically not described as bribe payments in the books and records, let's be honest, right? They typically come out in another way that just doesn't add up. So if you are in an internal audit or you're an external auditor, you really should be asking questions. And if you get the runaround and somebody just tries to just fob you off and just effectively dissuade you, you've got to make sure that you really don't get just fobbed off and that you do get the right. because so easily, and this happened in state capture in so many ways in so many places, you found somebody asked a question, they got a pretty weak answer, and they just left it because they didn't want to upset the client, or they didn't want to be unpopular with some business decision maker, right? And unfortunately, a lot of people have now made the headlines because of it. So no one wants to make the headlines. That's something we all want to avoid, at least for mistakes. But what's really important for accountants is be on the lookout, ask the right questions, and don't just let yourself get, I guess, fobbed off so easily where you haven't actually got comfort. If you're not comfortable, keep digging and make sure you get comfortable or deal with it. Right. So that's the best advice I can give. Obviously there's a role for accountants to be playing in terms of saying to their clients as well, have you adopted adequate procedures? Because this is just a simple win for you to comply with this new law, and you really should be doing this. And that should be something that is really ingrained in clients, and helping clients then do it, right? You don't have to be a lawyer to tell a client, you should have policies, or you should be doing a risk assessment, right? Those are things that auditors, if they are suitably equipped to do it and they're upskilled in that, they can be doing, right? You don't have to be a lawyer to do that. So I suppose that's just my practical advice. Obviously, different people have different views, but I think, hopefully the message is loud and clear. Auditors, in terms of preventing, should be on the lookout. And then in terms of this new law, they should certainly be encouraging clients to do this. And where they have been upskilled on helping implement these measures, they should certainly be doing that for clients. It's a great business for external, accountants, lawyers, and compliance practitioners. And it's good for their clients because you're helping clients stay out of trouble.
Yeah, that is a great ending to our interview. That's a very hands-on practical approach. Thank you for sharing that. I couldn't have said it better. I can just see an accounting firm, an external accounting firm, opening up a section for a business model on outsourcing the social and ethics committee to its firm. Now, the Companies Act prescribes them for the ones with a very high PIS scores, but with these new changes in legislation, maybe it's all necessary for all companies to have that type of committee, just to check maybe once a quarter in their compliance. Thank you very much, James, for sharing your insights with us, especially this last part. I think that was super helpful. And then for anybody that wants to connect with James, he's on LinkedIn, just LinkedIn Edward James, and subscribe and follow him. And then, maybe set up an appointment. He can just be the right person that you've been looking for. Thank you very much, James, for the podcast.
No, thank you for your time. Only a pleasure to share. And I hope that all the accountants out there manage to get on top of these laws and keep their companies out of trouble.
Thank you, James. All right.
Thank you. Cheers for now.
What do our defining moments look like? Just like this moment right now. They look like pride after achieving that long sought-after goal. All the small victories along the way that didn't feel momentous until we saw them in the rearview mirror. They look like the courage it takes to take that first big step. All the times we fail and rise again. And without even knowing it, cultivating an inner strength that is contagious along the way. They look like the inspiration that comes from knowing that we are not alone. They look like the human relationships that give us wisdom beyond what data ever could. They look like the curiosity that comes from exploring, that allow us to create and contribute. They look like education that unlocks our full potential, using our knowledge for impact. They look like choosing our own definition of success, over hiding, over hustling, over pretending. They look like others showing up and recognizing our efforts after all the times we already showed up for ourselves. They look like being bold enough to be extraordinary. They look like you. Right now, right here. First, we help you see your defining moments. Then we help you seize them. We are the accounting body for everyone. We are the accounting body